gridlock, and the founders recognized that King George was putting them into a state of war with all of the things that he was doing to their freedoms, colonies. And that was their justification for saying, King George, we can now be separate from you. The I&R process is rooted in the most basic of American principles. The I&R process is central to a peaceful society, one that need not resort to violence as our forefathers were forced to. They didn't have the I&R process. So, although the Second Amendment is our ultimate check and balance of government, we need not get there if we keep the I&R healthy. Does that help you understand maybe just how important this is? Folks, we could be saving scores and scores of lives by keeping this process alive. So, what about Missouri? Through our eminent domain project, we learned a whole lot about the ballot initiative process. I've been only tangentially involved in it until a few years ago. And one of the things that we learned is that it's an expensive process. Even if it's a true 100% grassroots process, it's still expensive. I've devoted most of the last 3 years to getting this 90% issue on the ballot before the people. It's cost me and my family dearly in lots of measures. So even if you don't ever spend $1 on it, you have lost income, you have lost opportunities, you have lost time with your family. It's expensive in a lot of different ways. It's expensive monetarily, typically. And you know, the people that might invest in the process are wary of it because they recognize that it's wrought with uncertainty. Why do you want to invest in a process that may end up failing? In fact, most of the time it does end up failing in one fashion or another. So it's expensive and it's hard to raise funds for it. Time's limited. The system favors opponents who can pile a lot of money in the way of success. People with the most lawyers, we failed folks. A couple months ago, we took the Secretary of State to court over not certifying our ballot, our petition. We had our one lawyer, and there were 12 lawyers from the biggest law firms in the state facing us. They could throw all kinds of money, all kinds of roadblocks in the way of our success. Something that I learned I really didn't understand, I don't think has been talked about yet here this morning, but a lot of the case law that has been established dealing with the I&R process has been determined in haste, in short periods of time, at least in Missouri. In Missouri, if there's a challenge to a petition, it's supposed to go to the top of the docket, it's supposed to get precedence and so forth, but you only have days, maybe weeks, to litigate the whole thing. In our case, there were some times when briefs were required for 24 hours. How can you really do a detailed legal analysis and present a judge or a panel of judges with the tools they need to make a good decision in 24 hours? It can't be done. So what we end up with is we end up with court decisions that were made in haste, setting precedents that in turn are relied on in the future to set more bad precedents. And so we need some de novo look at this process. It's we have a lot of unraveling to do before we can fix some of the problems. The legal challenges. Well, I might mention this too. The result then too is that judges understandably sometimes rule in very ambiguous ways. And so then if you come back the next year, as we are going to do, you're left still with uncertainty about how to fix the problems that you faced the previous election cycle. So one of the things that we need to deal with is we need some certainty. You know, it almost doesn't even matter so much. I think Edie's told this to me before. It almost doesn't matter so much whether it's hard or easy, but at least we need to know what kind of rules we've got to deal with. What are the rules of the game? I think Paul would concur with this. If you really knew what it took to be a resident of the state of Oklahoma, well, then you could comply with it. When they leave it ambiguous, and then what they can do is they can set up you for arbitrary application of whatever laws there are. And so those who are favored by the powers at large, maybe they don't apply. 1 minute, boy. And if you're not favored, well, then they can throw the book at you. So we have lots of concerns. We've got to really sit down and think about what is most important to us. And I would say some consistency is one of those things. I'll conclude by pointing out that in 2008, we face a tremendously severe challenge to the initiative process in Missouri. It skated through the House of Representatives, it skated through the Senate, and in the 11:30th hour, it was finally killed on the Senate floor. This was like the second to last day of session. It was a session that went until 4 o'clock that morning, and twice that day, it came to the floor. This year, the majority floor leader is the guy that handled that bill in Missouri. The people that want to curtail the ballot initiative process, at least in Missouri, they have some sway, and they'll try again. We need to be organized. We need to have our act together, and I think we need to go on the offensive. We're going to preserve this most important of our constitutional rights. Thank you.